Hello and welcome to the Forbes Solicitors Contentious Trust and Probate Team Q&A. I'm Kirsty McNulty. I'm an Associate Solicitor in the department and specialise in all areas of contested wills, probate and trust matters. I am going to be interviewing my colleague Tom Howcroft today on a number of matters relating to contesting wills and problems that arise with estates and the various disputes that can lead to. Tom is also a specialist in all areas of contested wills, trusts and probate, and hopefully he's going to give us a really good overview into the various topics today. So the questions that I'm going to put to Tom are questions that we are generally asked on a very regular basis. It's the majority of what our enquiries are about. So hopefully this will just give a little bit of an overview into the various matters. So Tom, the first question is, what are the grounds for contesting a will?
Okay, so there's a number of ways that you can contest the validity of a will. And the main ones usually we find are want of due execution. So that's basically, does the will itself fulfil the requirements that are set out under the Wills Act? So for example, has it been witnessed? Has it been signed? Another example of a grounds for contesting a will is lack of testamentary capacity. And that's usually along the lines of, did the testator, so the person who was making the will, did they have the requisite capacity to know what they were doing at the time and enter into those terms? And another common ground that we find is undue influence. So that's where quite often the circumstances will speak for themselves, and where a testator has been unduly influenced or forced into entering into that will. And a final ground is knowledge and approval. So basically, did the testator know and understand the terms of the will that they were executing?
So if somebody feels that they qualify on one of those grounds, how do they actually go about contesting a will?
Okay, so the procedure for contesting a will, what we would look to do is we would investigate and we'd need to find what evidence is present in support of the potential challenge to the validity of the will. So the relevant evidence would usually be with those who drafted the will. So if it was drafted by a solicitor, we would make inquiries with the solicitor, or maybe with those who were present at the execution of the will, such as the witnesses. If, for instance, we're disputing the testator's capacity and saying that they didn't have the capacity to make the will, then evidence may well be found within medical records. So we quite regularly will obtain and review the records for the deceased as well. Once we've obtained and reviewed all the relevant evidence, we'll provide a written advice on the prospects of the claim and the options going forward. So the first step in a claim would usually be sending a letter of claim to the executors and the beneficiaries in the will, setting out full details of the proposed claim to see how they're looking to respond to it.
So one of the main enquiries, I guess, that we usually have is people that are aggrieved that they haven't been included in somebody's will, be it a family member or a relative, or they thought that they were going to be included in somebody's will. So who can make a claim against an estate under the Inheritance Act?
Yeah, so there's several classes of people who can make a claim under the Inheritance Act, and that includes spouses, children, and those who are financially dependent on the deceased. So the claim that they would be making is for reasonable financial provision from the estate. And the court will look at a number of factors in deciding whether the claimant should be awarded financial provision. So even if you're already due to receive something under the will, if the court decide that isn't financial provision, then they may award over and above the current provision that's set out in the will. So it doesn't extinguish your potential claim under the Inheritance Act if you're already included in a will. And we'd usually, in Inheritance Act claims, we'd usually take instructions on the relevant factors under the Act, advise on the prospects of the claim, the options going forward, and we can deal with these types of claims on a range of different funding options, that's most suited to the client. So if we can discuss those and suit them to the individual at the time.
So if somebody decides that they want to go ahead and contest a will, how long have they got to do that? Is there any time limitation?
So in terms of challenging the validity of a will, there's no immediate timescale for that. So of course, if the estate's already been distributed, then it will make it much more difficult to recover money or assets from the estate, especially, of course, if they've already been spent. So we'd always advise, if you're challenging the validity of a will, on acting as soon as possible after the deceased has passed away. In a claim under the Inheritance Act, it must be issued within 6 months of the date of the grant of probate or letters of administration. So a claim can be issued after that 6-month period, but it would require the permission of the court and may be difficult. So it would always advise, again, in those instances, to make inquiries as soon as possible after the deceased has passed away.
So in an estate, Tom, where probate has already been granted, is it still possible to be able to challenge the validity of that will, as I say, if probate's been granted?
Yes, it is. Yes, so you can still challenge the validity of a will after probate's been granted. But as I say, we'd always want to try and take steps to investigate and obtain the relevant evidence before the estate's been distributed. And once they've got that grant, they can take steps to distribute the estate. So we'd want to make those inquiries as soon as possible, but it doesn't put a bar on it if the grant's already been issued.
So in terms of timescales, if somebody has good prospects and decides to bring a claim, what is the likely timescale for that type of matter to settle, Tom?
So with litigation, it's very difficult to provide an accurate timescale as to how long the claim will take, because it depends on a number of factors. Two of the main factors are the opposition's response, so how they're looking to defend the claim, whether they're willing to consider settlement or looking to defend it through to trial, and also the court's capacity. So if you do need to issue the claim, it'll depend on how busy the courts are. If the opposition are willing to settle at an early stage, then we'd usually look to try and settle the claim within the first 6 months or so. But if it is being defended to trial and they disagree with the claim and don't want to settle it, or if there's difficulty in obtaining relevant evidence, then it can be in excess of 12 months. So it's difficult to say exactly, but you'd usually look between the first 6 months to settle or up to 12 months or over if it was being fully defended.
Another question that we have actually had quite recently is, if an executor has an issue with the validity of a will, are they able to contest it?
So yes, the simple answer is yes, you are able to contest a will if you are an executor, but usually they would be required to renounce their role as executor of the estate due to the obvious conflict of interest that would be present there in claiming against the estate and being an executor as well.
And if somebody did decide to proceed with contesting a will, is it always the case that you would have to go to court for the matter to be finalised, Tom?
So in these types of claims and in the majority of civil litigation now, the majority of claims that have good prospects of success will settle before trial or well before trial, and that's due to the costs, the legal costs and the risks involved with going through court proceedings. So we'd usually look to try and settle it by way of negotiating, so offers between the parties, or mediating, which is where there's an independent third-party mediator present who encourages the parties to try and settle the claim. And we usually find that the majority of good claims will settle by those means. However, if agreement can't be reached between the parties, then the claim would need to proceed to trial and the court would need to decide the outcome.
So we briefly touched on executors. What should an executor do who is dealing with an estate who then is given notice that another party is going to make a claim against that estate?
Yeah, so if you've been informed that there's a claim being made against the estate where you're an executor, we'd suggest that you inform the opposition as soon as possible that you are obtaining legal advice, and you'll provide a response to them in due course, either yourself or through your legal representative. We can then take instructions from you. We can review the relevant documentation that's provided by the opposition or that's present from you, and we can then advise on the legal position and respond to the proposed claim with a view to trying to resolve the dispute as quickly as possible. Again, with those types of claims, if you're acting as an executor, we offer a range of different funding options depending on the circumstances, so we can discuss which would be most suited depending on your position. I mean, if you administered and distributed the estate prior to resolving the issues or the dispute that's been proposed to you, then you may well become liable as the executor for the proposed claim. So it's always beneficial to take legal advice as soon as possible and not to ignore it.
So if an executor is dealing with an estate, obviously they have got certain duties that they adhere to. If you were a beneficiary to an estate and you're not happy with the way an executor is actually dealing with it, is it possible to have an executor removed from their role?
Yes, so an executor has a number of duties that they must adhere to. So if they're failing to do so, they can be removed from their role as executor, and it's something we come across quite regularly. So, for example, if an executor is failing to administer an estate in line with the terms of a will, or if they're being unreasonable in terms of the timescales for administering and distributing estate, then they can be held as what's known in breach of trust, and they could be removed from their role following an application to the court. The first step, we'd usually send a letter of claim which sets out all the details to the executor and informs them of the proposed application. So hopefully at that stage you'd be able to reach a resolution so that the application isn't required.
And the final question, Tom, is what is a caveat?
Yeah. Okay, yeah. So a caveat is a notice which is entered at the probate registry. It prevents any grants being issued in the estate. So that's where once you've got the grant, you're able to administer the estate. So it stops that grant being issued. And there's a fee payable to the probate registry of £20 for the caveat. It remains in place for 6 months, but it can be subsequently extended. And we use them regularly in validity challenges. So if someone's got concerns about the validity of a will and we need to make those inquiries for medical records or for solicitor notes from the drafting solicitor, then we'll put a caveat in place to stop that grant being issued, to allow us to make those investigations and to be able to advise you appropriately on the claim.
Thanks for that, Tom. Well, that concludes our questions on this topic for today. And I think that Tom has given us a really good overview there. Obviously, any of the issues covered today are issues that we are able to specifically deal with. So if anybody has any other questions or queries, obviously you can contact myself or Tom. Our contact details will come up on the screen following the ending of this film, and we can be contacted by telephone or email. So that's it from us for today. Thanks very much for watching and take care.